Well, welcome back to chapter number 3, and we're going to talk in this final chapter of our course about misconduct by notaries or other people relating to the notarial acts. So far, we've been primarily discussing laws relating to the function and duties of a notary, but now we're going to turn our attention to laws that specify fines and penalties and legal consequences of misconduct. We're going to focus on misconduct by the notary, of course, but we're also going to address those instances when a person who's not a notary violates notary law. For example, you might remember that it's a misdemeanor for an employee or anyone to attempt to coerce a notary into completing an acknowledgement or jurat for a person who does not physically appear before that notary or who refuses to submit to the required identification processes. Misconduct by notaries or others in connection with notarial acts may be addressed through criminal, civil, or administrative laws and proceedings, and we're going to talk about those. Criminal misconduct may be a felony, misdemeanor, or infraction. A felony is punishable by a term in state prison or in county jail, and a fine might be imposed in addition to any kind of incarceration. A misdemeanor is punishable by a term in jail, probation, a fine, or all three. An infraction is punishable by a fine. Now, of course, criminal misconduct may result in the revocation, suspension, or denial of a notary public's commission or application. Civil misconduct subjects a notary public to fines and may also lead to suspension, of course, or revocation of the notary public's commission or denial of the notary public application. Also, a notary public and the sureties on the notary public's official bond are liable in a civil action for all damages, not just the $15,000 bond, but all damages sustained from the notary public's misconduct. This once again means that the notary public and the sureties on the notary public's bond are liable for all of the damages caused by a notary's illegal actions or misconduct. In other words, there is no limit. That's why most notaries will obtain E&O insurance. It's not very expensive, and it's very much worth the piece that you get from it. Now, administrative action can be taken against a notary public or notary public applicant to suspend or revoke a notary public commission or deny the application for failing to discharge the duties and responsibilities required of a notary public. Let's start off by mentioning that a notary must always be careful about not performing a notary act for which he or she has a direct beneficial or financial interest. Now, sometimes it's obvious when a notary has a beneficial or financial interest. For example, if a notary is the grantor or grantee for a grant deed which transfers property, clearly and obviously the notary has a direct financial and or beneficial interest in the document. And of course, the notary cannot complete the notary act with respect to the signatures on that document. So any document in which the notary is named as the beneficiary, principal, or interested parties clearly means that the notary has a conflict of interest and cannot notarize signatures on that document. Obviously, as we've said before, a notary may not notarize his or her own signature, but may notarize the signature of his or her spouse or domestic partner. But keep in mind that since California is a community property state, it's really important for the notary to exercise great care when performing notary services for a spouse or domestic partner in order to avoid potential conflicts of interest. So, if a notary public is named individually as a principal in a financial transaction, the notary public has a direct financial or beneficial interest in the transaction and a conflict of interest, and of course cannot perform the notary act in connection with that transaction. Now, for example, if a notary public is named as a party in a contract or is assigned the proceeds of a sale, the notary public has a direct financial conflict of interest and must not perform the notary act in connection with that transaction. It should also be clear that a notary has an obvious beneficial or financial interest in the document if he or she is listed as a grantor, grantee, mortgagor, mortgagee, trustor, trustee, beneficiary, vendor or vendee in the transaction. But what about a property that's being leased? It turns out that if a notary is named as a lessor or a lessee on a property, the notary may not perform the Notary Act in connection with that property. So, what about some other instances when it may not be quite as obvious as whether or not the notary has a direct beneficial or financial interest in the document? What if, for example, you are an employee and your boss wants you to notarize his signature on a contract bid that relates to the company? Are you allowed to notarize that? Well, as it turns out, there's a specific notary law that will help you to be able to decide whether or not you're permitted to act as a notary in instances that may be otherwise unclear. The notary public, acting as an agent for another person, can perform notarial services for that person. Also, if a notary is an employee for a company that will receive benefits or money from a transaction, the notary public can still perform the notarial services in connection with that transaction. The notary public is not benefiting directly, even though the notary public's employer receives a benefit. Okay, this is worth repeating. The notary law that I'm referring to states that if a notary public acts as an agent, employee, insurer, attorney, assuming that the notary public is admitted to practice law in California, escrow, or lender for another person who has a direct financial or beneficial interest in the transaction, then the notary public does not have a prohibited direct financial or beneficial interest. Of course, this always assumes that the notary is not named as the principal in the document that's going to be notarized and is, of course, not the signer of the document, nor is the notary specified in the document as a beneficiary. Now let's talk about giving legal advice or practicing law, particularly those notaries who do not have a license to practice law in California. Look, many people choose to forego seeking the advice of an attorney because they believe that the notary has legal authority to assist them, and that's going to save them a lot of time and money. Unfortunately, sometimes notaries do take advantage of that misperception, or often even the notary may not realize that they've crossed into an area of giving legal advice. So we're going to clear that up. Since a notary public comes into contact with a large number of legal documents, from deeds to wills to contracts, among many others, there might be a temptation to offer advice or comment on the legal aspects of a document rather than just carrying out the notarial activities alone. But it's very important to remember that a non-attorney notary public cannot undertake any acts that constitute the practice of law. Among the acts that constitute practice of law are the preparation, drafting, or selection of legal documents, or giving advice with relation to any legal matter or legal document. For example, suppose a customer brings a document to a notary without a notarial certificate and then asks the notary public to notarize it. The notary public cannot provide advice or decide for the customer whether a certificate of acknowledgement should be completed or whether a jurat would be in order. The customer must decide. So if the customer is unsure, the notary public should recommend that the customer confer with the party receiving the document, or that the customer should consult with an attorney.